Hey there, my friends! Welcome to those of you watching us for the first time. And to those of you already sharing this journey with the Academy, thank you so much for joining me again. Here, we're exploring international law. The two playlists mentioned above are the paths we have taken so far, and I am here to take it further by drawing the law alive. We are talking about subjects of international law, which you can revisit in the created videos in my playlist above. And today, we're continuing our discussion about the last element of state, government. Ready your curiosity, and let's begin this new chapter together. When we speak of the government as an element of statehood, we step from the realm of sovereignty, the soul of authority, into the realm of structure and movement, the hands and voice of the state. The government is not sovereignty itself, it is its living form. It is the organized authority that administers the law, commands obedience, and represents the state in the eyes of the world. Through it, sovereignty finds expression and order. Without it, the state's will would remain only an idea. In international law, the government stands as the legal representative of the state. It speaks on its behalf in treaties, in diplomacy, and even before international courts. Its signature binds the nation. Its actions are the state's actions. The government is the face by which the state enters the community of nations, an embodiment of its legal personality. Yet governments come and go, while the state endures. Revolutions may shake power, coups may replace rulers, constitutions may be rewritten, but unless the very identity of the state dissolves, international law maintains the thread of continuity. The legal person of the state persists, even as its governing form changes. Still, a government's legitimacy in the eyes of international law is tied to effectiveness. It must exercise real authority over its territory and population. This principle, flowing from the Montevideo Convention, tells us that government is not a mere title. It is a function performed in fact. The law recognizes the power that governs effectively, not just the one that claims to. And so, international law distinguishes between de jure governments, those established by law and constitution, and de facto governments, those that have seized control but hold it in practice. The world may hesitate to recognize the latter, yet their actions still carry weight in law, for they exercise the reality of power. Thus, the government is both a structure of administration and a symbol of legitimacy. It bridges the abstract idea of sovereignty with the tangible world of governance and responsibility. Through it, the state breathes, acts, and takes its place among nations. To know the forms and systems of government, we must enter the gallery of political design, where states arrange their authority, distribute their powers, and shape the rhythm of rule. International law stands at the doorway of this gallery, observing without judgment. It does not command a single model of governance. It merely asks that a government exist, effective, stable, and capable of representing the state. Beyond that, the architecture of power remains the sovereign choice of each nation. In the classical sense, governments are divided by their form: monarchy, republic, or variations in between. In a monarchy, authority flows through lineage. The head of state embodies continuity. In a republic, authority rises from the people, sovereignty expressed through representation and consent. Both, in the eyes of international law, are equal, for legitimacy is not in the crown or the ballot, but in effectiveness and legality. Then comes the system of government, the internal choreography of power. Here we meet the presidential, parliamentary, and hybrid systems. In the presidential model, as in the United States, the executive is independent from the legislature, chosen directly or separately by the people. In the parliamentary model, like the United Kingdom or Italy, the executive emerges from the legislature and remains answerable to it. The hybrid or semi-presidential form, as in France, balances both, a dual executive sharing authority between a president and a prime minister. International law does not interfere with these choices, for they belong to constitutional design, not global regulation. Its neutrality is anchored in the principle of sovereign equality. Each state, whatever its system of government, retains the same legal personality and rights under international law. The world accepts monarchies beside republics, parliaments beside presidencies, so long as they function, so long as they represent a living authority. Yet the system of government deeply affects a state's international behavior. It shapes how treaties are ratified, how foreign relations are conducted, and how responsibility is assumed for wrongful acts. It influences who may speak for the state, a king, a president, a parliament, or a council, but never changes the unity of the state's international identity. Thus, international law looks not into the form of the government, but into its capacity. What matters is not who rules, but that someone rules, lawfully, effectively, and in continuity. Every government, no matter its form or philosophy, operates within a constellation of international principles, invisible lines that shape its conduct and safeguard its independence. These principles are not imposed. They are woven into the very fabric of international law, balancing the freedom of governance with the harmony of coexistence. The first and perhaps most sacred among them is the principle of sovereign equality. Every government, whether vast or small, ancient or newly formed, stands equal before the law of nations. No government may claim a superior right to existence or to participation in the global order. This equality is the foundation of diplomatic relations, of membership in international organizations, and of the shared legitimacy of all states. Equally foundational is the principle of prohibition of the threat or use of force. Governments must not employ power to impose their will on others. Article 2.4 of the UN Charter anchors this rule, allowing force only in self-defense or under UN Security Council authorization. By restraining the logic of might, this principle ensures that the international order is guided by law rather than power. Next comes the principle of non-intervention, a guardian of political autonomy. No state has the right to intervene, directly or indirectly, in the internal or external affairs of another, especially in the choice or change of its government. This rule, enshrined in Article 2.7 of the UN Charter and reaffirmed by countless resolutions and judicial opinions, shields the internal will of peoples from external pressure. A government, to be lawful and respected, must arise from within its own society, not from foreign design. The third guiding thread is the principle of self-determination of peoples, which gives moral depth to the previous two. It reminds the world that the legitimacy of government flows from the consent of its people, whether through decolonization, democratic participation, or national unity. Governments derive their authority not merely from effective control, but from the right of a people to determine their own destiny. Another essential principle is the continuity of state despite changes in government. International law draws a clear line between the state and its government. The fall of a regime, the rise of a new political order, or a shift from monarchy to republic does not extinguish the legal personality of the state. Treaties, responsibilities, and rights continue because the state endures beyond the hands that govern it. The principle of good faith binds governments to act with honesty and reliability in their international conduct. It is the moral compass of diplomacy, ensuring that commitments are honored, treaties respected, and international obligations fulfilled with integrity. And the principle of peaceful settlement of disputes stands steadily here as well. Disagreements are inevitable, yet law transforms them into dialogue rather than conflict. Every government is obligated to resolve disputes through negotiation, mediation, arbitration, or judicial means, reflecting the idea that true peace is achieved through lawful resolution, not coercion or force. Alongside restraint, international law demands cooperation. The principle of cooperation and friendly relations affirms that states, while sovereign, exist in a shared system that thrives on collaboration. From joint economic initiatives to collective environmental protection and humanitarian aid, governments are called to harmonize their sovereignty with mutual responsibility. Interdependence transforms independence into an opportunity for dialogue, not isolation. Finally, legitimacy and authority are inseparable from the protection of people. The principle of respect for human rights and fundamental freedoms reminds governments that their power carries duties toward the individuals under their care. From the Universal Declaration of Human Rights to binding covenants, this principle ensures that sovereignty is exercised with dignity, equality, and justice. turning the authority of the state into a moral and legal pillar recognized by the community of nations. Together, these principles form the ethical and legal framework guiding governments in the international arena. They balance sovereignty with responsibility, freedom with duty, and power with law, defining the essence of a government in the world of international law. The next important part of talking about government of a state is immunity. State immunity is the principle in international law that protects a sovereign state from being sued in the courts of another state without its consent. It reflects the equality and independence of states, ensuring that no state can unduly interfere with the internal affairs or legal standing of another. Imagine each state as a luminous island in the vast ocean of international law, and immunity as the gentle water that surrounds it, shielding it from being engulfed by the waves of foreign judicial authority. There are two main strands of this protection. Jurisdictional immunity prevents a state from being dragged into the courts of another state without its consent, keeping the judicial hands delicately restrained. Immunity from execution protects a state's property abroad, ensuring that foreign courts cannot seize embassies, official buildings, or assets used for governmental purposes, except in narrowly defined situations, like commercial property under international conventions. Executive immunity, meanwhile, shields officials acting in their official capacity, protecting them from foreign judicial scrutiny while performing state functions abroad. Together, these forms of immunity preserve the balance and respect among sovereign nations. Historically, state immunity was absolute. No state could be brought before foreign courts under any circumstance. Over time, as states increasingly engaged in commercial and private activities, the principle evolved into restrictive immunity. Now, a clear distinction is drawn between sovereign acts, jure imperii, which retain full immunity, and commercial or private acts, jure gestionis, which may be exceptions, allowing foreign courts to adjudicate them. This evolution balances sovereignty with fairness in cross-border interactions. International law has codified these principles in key instruments, most notably the 2004 United Nations Convention on the Jurisdictional Immunities of States and Their Property. The convention clarifies the types of immunity, their limits, and the treatment of state property abroad. It establishes that judicial immunities protect states from being subjected to foreign courts, while executive immunities shield officials performing state functions. Property used for commercial purposes may fall outside immunity, offering courts a pathway to enforce legal obligations in certain cases. According to the 2004 Convention, exceptions to state immunity exist in cases such as commercial transactions, contracts of employment, or personal injury and property damage arising from a state's commercial activity. These carve a careful path between respecting sovereignty and ensuring that states cannot exploit immunity to escape responsibility for private or commercial acts. Officials acting on behalf of a state enjoy special protections. Heads of state, diplomats, and other high-ranking officials may have personal immunity for acts performed in their official capacity, sometimes even while traveling abroad. After leaving office, immunity usually only applies to acts undertaken in an official role, leaving personal acts outside protection. This ensures that the shield of immunity follows the flow of authority while still maintaining accountability in appropriate contexts. State immunity is not a fortress, but a living principle, a subtle legal current that respects equality, safeguards sovereignty, and navigates the complex waters of international law. It reminds us that states, though sovereign and free, remain part of a shared legal universe, protected in some spheres, exposed in others, and always connected through the delicate threads of law. Unlike immunity, which shields a state from the reach of foreign courts, state responsibility is about accountability, the compass that shows a state must answer for its actions. It reminds us that sovereignty carries not only rights, but also duties, and that states, like individuals, are bound by the legal currents of the world. Imagine the government of a state as the heart and hands of a luminous island. When these organs act, their strokes ripple across the ocean of international law, leaving traces that the legal currents carefully observe. State responsibility arises from the acts or omissions of the government and other organs or agents acting on its behalf. Every action taken by ministries, officials, or state-directed entities can generate responsibility, for these bodies are the living voice of the state. Even private individuals may trigger state responsibility if the state authorizes, directs, or fails to prevent their wrongful acts when it has a legal duty to act. In this way, the state is accountable through the conduct of its government, the seat from which authority flows. The principle is codified in instruments such as the Draft Articles on Responsibility of States for Internationally Wrongful Acts, 2001, by the International Law Commission, which define what constitutes a wrongful act, how it is attributed to the state, and what consequences follow. International law distinguishes between primary obligations, the substantive duties that states must follow, like respecting sovereignty, human rights or treaty commitments, and secondary obligations, the duties to make reparation when breaches occur. A wrongful act of a state can take many forms: unlawful aggression against another state, violations of human rights obligations, breaches of treaties, or damage caused by commercial or administrative activities. Even acts by officials, armed forces, or other state organs performed in their official capacity are attributed to the state. These acts may be direct or omissions. Failing to act where the law imposes a duty can equally trigger responsibility. When a wrongful act occurs, international law responds with measures designed to restore legal balance. The primary response is reparation, which may take the form of restitution, restoring the situation to what it was before the act; compensation, covering damage when restitution is impossible or insufficient; satisfaction, such as acknowledgement, apology, or symbolic remedies. In addition, serious wrongful acts may provoke countermeasures by other states, including lawful suspensions of treaty benefits, economic measures, or diplomatic responses, all carefully calibrated to induce compliance without violating other obligations. State responsibility operates across time and space. It applies in peacetime and wartime alike, and some wrongful acts have continuing consequences, such as ongoing environmental damage or prolonged occupation. Though codified in the 2001 Draft Articles, state responsibility is deeply rooted in customary international law, allowing it to apply broadly even where treaties do not exist. In essence, state responsibility is the counterpart to immunity. While immunity shields the state from foreign judicial interference, responsibility ensures that the government's wrongful acts leave traces that demand acknowledgement, reparation, and legal balance. It is a living principle, a river of accountability flowing through the global legal landscape, reminding the world that sovereignty is inseparable from duty, and that acts of the government, whether grand or small, ripple through the fabric of international law. And so we come to the gentle yet powerful heart of the state, its government. We have explored its definition, its forms, and the principles that guide its actions in the intricate dance of international law. We have traced the delicate shield of immunity, which protects the state from undue interference, and the mirror of responsibility, which ensures accountability when the government's actions ripple beyond its borders. By understanding the government of a state, we have completed the portrait of the state itself, a living organism composed of its people, rooted in its territory, sustained by its sovereignty, and animated by the government that gives it direction, purpose, and life in the international arena. With this foundation in place, we are now ready to turn our eyes outward, beyond the state, to explore the broader stage of the international community, to the networks, instruments, and actors known as international organizations, where states converge, cooperate, and shape the rules that bind us all. And so, I hope you feel good about spending your precious time accompanying IntlLaw's journey with me so far. In our next videos, we will talk more about the other subjects of international law, okay? See you soon, my friends.